Just over 2 months ago, I announced the formation of an independent review team of district attorneys from around the state to assist in the evaluation of the case against Albuquerque police officers Keith Sandy and Dominique Perez in connection with the shooting death of James Boyd. I initiated this process because I believed that a comprehensive independent review of the available evidence and the applicable law would go a long way towards restoring public trust in the evaluation of officer-involved shootings. I also believed that my ultimate decision on how to proceed and move forward with this case would benefit from the independent assessment of prosecutors from outside this jurisdiction. Separate and apart from the work of the independent review team, however, I also concluded that it was necessary for my office to conduct its own internal review of the Boyd case. As such, upon assuming office in January, I directed 2 senior trial prosecutors within my office to conduct a comprehensive examination of the applicable facts and the law, including the course and conduct of the first trial, which ended with 9 of 12 jurors voting in favor of acquittal. These 2 attorneys conducted their review without contact or communication with the independent review team. Over the last 2 months, both the independent review team and my prosecutors examined all of the relevant facts and the evidence at issue in this matter, analyzed the court's rulings on pending and possible charges, and reviewed the testimony and arguments presented during the first trial. On February 20th, the independent review team notified me that it had completed its work and submitted an executive summary of its legal analysis, along with its recommendation as to whether or not the state has a sufficient basis to try this case again. After reviewing all of the facts and evidence, the 6 participating district attorneys were unanimous. In the absence of new evidence, and in light of the jury's 9-3 vote in favor of acquittal, their recommendation to me was that the case be dismissed. My own prosecutors, having no contact with the independent review team, and after conducting an exhaustive analysis of the first trial, reached the same conclusion, that in the absence of new and compelling evidence, there is no reasonable basis to conclude that the state would be able to meet its burden of proof at a second trial. For both teams, a key component of the analysis was grounded in the fact that the scope of the case is largely set, and that the remaining available charges are not likely to be proven beyond a reasonable doubt. The reviews recognized that the same judge, faced with the same facts and likely the same arguments by counsel, would likely rule in the same manner on any procedural, evidentiary, or dispositive motions brought in a second trial. In other words, we would expect the evidentiary and legal landscape of any subsequent trial to essentially mirror that of the first trial, which weighs in favor of not retrying this case. Most in this community have only seen a portion of what was presented to the jury during the trial, and have drawn their own conclusions about whether or not a crime was committed without the benefit of reviewing all of the evidence or considering the court's specific instructions on how the evidence must be evaluated under the law. Furthermore, there is no reason to believe the case against Officers Sandy and Perez could be tried better or more exhaustively at a second trial, or that a second jury would reach a different outcome than the first. In light of the instructions, and taken in combination with the broad statutory protections afforded to police officers under existing law, I do not believe that the state can prove its case beyond a reasonable doubt.